Hello and welcome to the AML Clinic podcast. I'm your host, Michelle Clement. In today's episode, we are talking about offshore jurisdictions. And this is one of those topics in AML where views tend to harden very quickly. For many law firms and compliance teams, the moment an offshore entity appears in a matter, it is treated as an automatic red flag. It becomes shorthand for opacity, tax risk, or potential criminality. And sometimes that instinct is absolutely right. I'm joined today by Colin Solomon, who offers a nuanced approach to offshore entities and questions some of the assumptions that drive risk perception. Colin is a senior specialist in offshore financial services, AML, and jurisdictional risk. With decades of hands on experience in complex, highly regulated environments, he is particularly known for navigating the practical realities of trust structures, fiduciary risk, and cross border compliance, especially where regulatory expectations meet operational reality. Colin, welcome to the AML Clinic.
Michelle, thank you. It's really nice to be in the clinic today.
Thank you for being here. You have what I describe as a more nuanced view of offshore jurisdictions than most people working in AML and legal compliance. But before we get into that detail, I think it's important to be clear about what we mean by offshore jurisdictions. So, in its broadest sense, offshore jurisdictions are countries or territories that offer low or zero tax regimes, higher levels of financial privacy, and regulatory frameworks designed to attract foreign or non resident business. They're often used for asset protection, cross border investment, succession planning, and tax efficiency. Common examples include places like the British Virgin Islands, the Cayman Islands, Seychelles, Panama, even US states such as Delaware and Wyoming, and of course, the three British Crown dependencies, which includes Jersey and Guernsey. Colin, question for you. How would you summarize your view on offshore jurisdictions and AML risk, especially compared to mainstream UK compliance thinking?
There is risk everywhere, Michelle, and there's risk everywhere whether a client is choosing to organize their affairs through a service provider in an offshore jurisdiction or they're a client of a domestic bank in the UK or using a law firm in the UK. Um, there is, as you put it in your introduction, there is an almost automatic response, almost an animal farm response, which is onshore good, offshore bad, two legs, four
Mm,
legs. And for me, that isn't nuanced enough because every citizen has the right to organise their affairs to maximise their tax efficiency. So if I choose to hold premium savings bonds because they're tax efficient, I'm doing nothing wrong. If I choose to be a settler of a offshore trust and my family members are beneficiaries of that trust,
mm,
I'm doing nothing wrong as long as I'm completing all of the necessary declarations and paying all the necessary taxes due. So I don't subscribe to the animal farm perspective, onshore good, offshore bad, because we only need to look at the solicitors' regulatory authorities' regular publication of who they've found at fault. We only need to follow the financial press. We only need to worry about bribery and corruption in the higher echelons of British politics to know that risk abounds. Um, I did want to say that for me, one of the things that marks out an offshore jurisdiction, and some of them don't have to be offshore, they can be onshore, as you referenced with some American states, and not all of these places are islands, is that often the importance of their financial services industry is disproportionate to the size of the location. So, staying close to home for me, an island I know well, I'm not resident there, Jersey, 45 square miles, 9 by 5, circa 105,000 people, and yet more than 50% of the economy, the gross domestic product, is derived from financial services. some tourism, some potatoes, but predominantly financial services. So for me, an offshore financial centre, though it doesn't have to be surrounded by water, it's about a disproportionately important financial services sector populated by experts. They can be leading accountancy firms, global law firms, and then increasingly global fiduciaries.
Okay, thank you. I'm just curious, what shaped your view? Are you talking from practical experience, the particular transactions that you handle that's given you this very nuanced view, as I call it?
Well, there are some transactions I'm aware of that I may have been an employee at a firm where the firm was involved, which are newsworthy, but they're
Mhm,
often either matters that have been dealt with without coming under full public glaze, or they have come under full public gaze. So, if you like, the cases which people tend to grip on, the red flags,
mm,
are the headline cases of criminals using offshore to conduct a Ponzi scheme, or people evading tax by placing assets offshore and then their criminality is not reporting the existence of them. There's a certain former Conservative politician, now a member of Reform Limited, who was not honest with HMRC about his tax affairs. And then he was
mm,
not honest with the press about his tax affairs. And he was, how can I put it, exposed by a leading commentator on this area. So, what shaped my view is needing to be aware of how anti money laundering measures take place across a number of jurisdictions from a practical, not a theoretical point of view. And when
mhm,
you deal with the practical, you have to start to understand that there are shades of grey. I might
mhm,
look at a situation and I might be suspicious. One of my colleagues might look at a situation and not be suspicious. But we're both right because suspicion is personal and subjective. So, what shaped my view is having to do it the hard way, having to make difficult decisions,
mm.
having to develop an ability to decide what's suspicious that's based on more than gut instinct.
Okay, I hear all of that. We're going to touch on how much of the perception of offshore jurisdictions is regulatory caution versus headline influence. But I just wanted to circle back very quickly. Do you think offshore jurisdictions are inherently high risk?
Can I answer that like all good politicians by saying what I wanted to say, which sort of answers your question and satisfies the question time audience?
Okay.
Um, there is the perception that offshore is inherently risky.
Mhm,
Undoubtedly, there are bad actors who choose to conduct their business offshore. I won't name one or more jurisdictions, but it's some jurisdictions, some to a greater or lesser extent. So there are bad actors who seek to avail themselves of the ability to falsely keep their wealth, their transactions, their activity offshore. There are then, I'm pleased to say, increasingly few practitioners who, instead of being a practitioner, end up being a facilitator. And either through ignorance, naivety, or some other coarser emotions, end up helping the bad actors carry out their their intent to hold on to their ill-gotten gain, if we keep it in the simplest of languages. So offshore isn't inherently risky, but it's arguably the risk is arrived at and perceived in a different way than it is onshore.
mm,
That having been said, we had the example with the NatWest in the UK where a client would come in with black refuge bags of cash, which would be banked. And on one occasion, as the criminal walked across the car park, his black bag split, and apparently a NatWest employee came out with a replacement black bag. And, the cash was introduced into the banking system.
mhm,
Placement in its intimate, simplest form. working offshore, working offshore for banks, trust companies, providing consultancy services to banks, trust companies, investment managers, law firms, estate agencies, you perhaps get a bit more confident in determining, well, that's risky but not too risky, or no, that's not risky at all. And there's a debate at the moment in Jersey that regulated individuals, regulated firms, should conduct enhanced due diligence where a transaction is complex. But that then begs the question, well, it may be complex to you, but is it complex to me? How do you define complex? Very, very, very difficult. And I've had this discussion with a number of practitioners, which is, well, the regulator's view might be it's complex if there's a number of layers in a structure. So there might be a trust, there might be one or more underlying companies which will hold assets. They might perceive that as being complex. But to many practitioners in the offshore trust field, that's not complex. That's bread and butter activity. So there is a nuance that needs to be achieved in that regard. So my perception on risk comes from the sharp end, I'd like to say, and needing to navigate those dangerous choppy waters. I mean, I'm being cynical and poetic in my
Mm.
choice of language, but there's risk in onshore and offshore, isn't there?
Yes, absolutely. So, not to chase the rabbit hole of what complex is, but this is why it's really important to have a very, very clear set of firm-wide risk assessments. So when I say very clear, you need to identify what your firm's risk exposure is, because as you said, what's complex to one firm is not complex to another. So that's where you'd be able to identify this is what the type of transactions our firm normally deals with. This is quite bread and butter for us, but actually where we normally just deal with for example, I don't know, a two-partner company, but we've now got this offshore structure who's come to us and wants us to act for them. Well, this is a bit more complex than something that we do. But I'm digressing. I'm going to move on now.
Can I say your
Um,
digression was lovely? It really
Thank
was.
you. Thank
It was the right element of nuance, because there's a world of difference between a two partner law firm in Llandudlo and a 500 partner law firm in London as to their perception of complex. And if I'm an offshore entity acting for a wealthy individual, and I go to that Ludlow two-person firm, why am I choosing that two-person firm in Ludlow when
Precisely.
surely the 500 partner firm in London, with international reach, with associated global offices, who can understand the tax planning and, more importantly, the tax compliance that's required for my client transaction, that's where I should be. The fact I'm not there, to my mind, is telling me something. I go back to
Mm.
Stanford, the man who wanted to take over world cricket. His auditor was a one-man auditor. So how can you have a billionaire's business empire with a one-man auditor? I mean, I see red flags, I hear alarm bells, and I'm saying, well, there is smoke because there is fire in that instance.
Yes, absolutely. So you've already mentioned before, there have been offshore jurisdictions have been repeatedly associated with tax evasion, secrecy, high profile scandals. I can't get my words out today. And over that time, that narrative hardens into a shortcut. Offshore equals opaque and opaque equals risky. How much of this perception do you think is regulatory caution versus media or headline influence?
Oh, chapeau, what a question. We have a problem, and it's with a small p, which is both the EU, America, and FATFA, the Financial Action Task Force, produce lists, and they put jurisdictions on these lists, either the super bad, the blacklist. These countries haven't got their anti-money laundering legislation and enforcement and supervision quite right yet. They're on a grey list. And then there are other people who aren't listed at all because they don't participate in the FATFA process: Russia, Belarus, China. And then there are others who do, who aren't listed. So they're not black, they're not grey, they do participate. By definition, they're no colour, or you might say they're whitelisted, but there is no whitelist. So the hardened perception is, if it's blacklisted, you will not touch that country. If it's a country where there are multiple sanctions in place, you will not deal with clients from that country. You can, but you're doing so with real risk. If it's clients from a country which is grey listed or recently grey listed, Cayman, BVI, others, then exercise some caution. If it's somebody from Jersey, Guernsey, Isle of Man, the overseas dependent territories or the Crown dependent territories, which aren't on FATFA's blacklist, aren't on the EU's third party high risk countries list, then you can treat people from there as if they're a normal risk. But that misses something. That misses something. What it misses is that Peter Mandelson represented a bribery and corruption risk. It misses that the Conservative who's just joined Reform represented somebody who was fined by HMRC. Risk is personal as much as it is geographical. And if I was born in Iran, educated at Eton, went to Cambridge, went to Sandhurst, does that make me an appalling risk because I happen to be born in that part of the world? Well,
Definitely not.
if you have a strict tick box, it does. But where's the risk? The risk is actually not necessarily so much where I was born, and I was born on the edge of Dartmoor in an idyllic, picturesque cottage. I'm just waiting for them to put the blue plaque up to note this event. But you have to look beyond tick boxes. You have to look beyond Iran bad, Ilford good.
Yes, I agree. Again, another risk assessment point, and very important for it not to be tick boxy. It needs to be decision based, risk based. The decision needs to be risk based, is what we're saying.
Well, can I jump in because you've lit my blue touch paper. You have
Right?
in the nicest possible way. A firm who, in their risk-wide assessment, says their firm-wide risk assessment says, well, we won't deal with logistics, we won't deal with shipping, we won't deal with these geographical areas. That's putting up a defensive measure. But if they aren't conducting, and it's about conducting due diligence, because due diligence is something you go through, it's a process. The bits of paper or the digital records you hold, they're evidence of what you have done. They are the byproduct of the conduct, and it's the conduct that matters. So you draw up this list of, we won't deal with X, Y, and Z, places, geography, sectors, which leaves you with the rest of industry, the rest of the world. So you will deal with them. But don't assume that in those other industries, in those other geographical sectors, there isn't criminality going on, because there is. And I'm not going to say it's happening more offshore than it is happening onshore, because it
Mm.
isn't necessarily the case. And this is where you lit my blue touch paper. The offshore jurisdictions, to a varying degree, have spent up to 2.5 decades making sure that they supervise, enforce, regulate their regulated industries, including lawyers, including accountants, to the ever heightening standards set by the Financial Action Task Force, which is established by governments, funded by governments, and governments try and have their businesses in their country meet those standards. So Jersey, as an example, agreed, set out its policy more than 25 years ago that it would try to be an early adopter of international standards. It would actually always seek where it was felt the right thing to do, that it would demonstrate that it was meeting international standards. So there are firms operating in Jersey who've been operating to a higher regulatory expectation than some law firms, accountancy practices in the UK. And they've been operating there some time. So that there are firms in offshore jurisdictions that have faced fines of £1 million for not having appropriate anti-money laundering systems in place. So when the SRA fines a firm in the UK £10,000, that's big news. When they're fined £100,000 and some partners are dealt with by the solicitor's regulatory disciplinary panel and have their license suspended, that's big news. But it's not big news in the context of how hard matters are being enforced in some of the offshore centres. But all offshore is not the same. Some
Mm.
offshore centres are actually, though they'd never admit it, they're deliberately being laggards. Sort of they're saying, well, we're making progress, but they're not trying particularly hard. Oh gosh, I'm going to get into trouble for that. My inbox will be full of hate mail from certain friends in certain jurisdictions.
You didn't name any jurisdictions, so that's
I
okay.
didn't. You can tell I've. This is not my first rodeo. Um, That said, just because a country is not on a blacklist, not on a grey list, that said, because a firm in that country has been meeting international standards for a long time, and in that country, the authorities, the government, the elected government, the legislature is keeping the island's industry held to the tightest control, the highest standards, doesn't mean there isn't criminality happening there. So I genuinely believe saying onshore good, offshore bad, it's wrong. It can't possibly be right. Saying that Jersey is good and another is bad, that's less right, or is it more right but still a bit wrong? I'm not sure which. So in all of this, a firm decides it won't deal with X industry or X geography. Okay. So that leaves, as I've said, the rest of the world, the rest of the industry. But you can't then assume that everything that's left, that things that you will do, is all okay. Because if you don't conduct that client due diligence properly and understand it, as in it's not a tick box exercise, it's not a collection, it's about what have I discovered during conduct, because it's what I've discovered that enables me as an intelligent professional to say, I don't think we should take this piece of business on. The
Mm.
risk exceeds the reward. If
Mhm.
I'm going to be on the front page of the FT tomorrow, I'd like it to be because I've done something good.
What you've spoken about really speaks to the heart of the risk-based approach, doesn't it? And I think what's quite interesting for me from everything you said is the irony in the fact that some offshore centres now have tighter AML controls, more transparency probably, than parts of the onshore world, but that doesn't ever make the news.
Well, some organisations, some jurisdictions have got a bigger voice. They get more airtime. I like to think of this as the do as I say, not as I do paradox. Jersey has, sorry, Guernsey has this, the Isle of Man has this as well. They have a finance promoter, and government money goes into the finance industry promoter to talk about how the opportunities exist, how well regulated it is, and that's true. But if you're a small offshore jurisdiction, you're not going to get your voice heard as well as the government of the UK, the government of America.
Mm.
So there is this paradox, which is we might be better regulated in some offshore jurisdictions with fewer rogue clients, fewer rogue firms. The UK, America might be less well regulated, gosh, I said that out loud, or not so far along the road to what I like to describe as fat for nirvana. Fat for nirvana is when every firm in that jurisdiction is working to the standards that the jurisdiction has brought in and resourced, and everybody is trying to do the right thing. So the chances of criminality happening there is at its minimum. Can't be nil. The only way to have no risk is to do no business. So nowhere is at fat for nirvana, but some places are trying harder to get there than others.
You are shaking some serious tables here, Colin. Shall we move on to some practical takeaways, actionable takeaways for law firms?
Do you mean the question you asked me in advance so I would have a good answer?
That one, yes.
Okay, go on then.
Right. So when firms are faced with an offshore entity and need to understand beneficial ownership properly, what practical steps would you recommend they take? That's
It
the
would be,
first step of
it
that's
would
the
be
first
wrong.
part.
It would be wrong of them to say contact me. It would. What they can do is they can ask the client to explain why the arrangement is set up in the way it is. If
Okay.
the client cannot explain why they have an offshore trust and company structure, it might still be okay, but it might not.
Mhm.
If they can't explain it to my satisfaction, and I'm never going to assume that they're more intelligent than me, which is why I don't understand, I'm going to assume with all of the inherent risks, so let's not go with assume. I'm going to think, well, they've just not explained it well enough. I will ask them to ask their offshore service provider to explain how this works to me. And if I
Okay.
don't understand it, I'll get a second opinion on what I've just been told. If the offshore service provider can't explain it because they say, oh, well, we rely on international tax advice from a King's Council in the UK, I'd think, well, you're not necessarily up to this role either. So I would ask the client to explain it. I'd ask the client service provider to explain it. I'd ask them all to put it in writing. If it
Okay.
doesn't add up, it doesn't add up. Nothing is ever too good to be true. Otherwise, I'd be a multi-millionaire rather than just somebody who enjoys life. So I'd ask the client's advisors, I'd question, do I understand this? Because if I don't understand it, I don't want to deal with it. And if I have no experience dealing with a shipping agent who leases oil cargo ships that can sail from the Mediterranean to South America and back again to Asia, then why would I want to take on a client who does that? Why would I want to provide legal services to a shipping agent who arranges for cargo vessels to be hired in the Mediterranean to sail to South America to sail back to Asia? I just wouldn't do it, would I? But the
Doesn't sound like
fees,
a good idea.
the fees huge, and all we have to do is draft a contract. Okay, then, fees huge. All you have to do is draft a contract. I'll see you on the front page of the FT. Oh, sorry, I'll read about you on the front page of the FT. I do like shaking tables, as you put it, but I do think sometimes there is an enthusiasm on the part of fee earners to say, "Oh, we can do this. We can do this. Look at the size of the fee." I whispered that bit. Whereas fee earners should, to some extent, be their own gatekeepers, their own thought police, which is this is too good to be true. And those individuals, and I salute you because you're heroes, and not all heroes wear capes, holding the compliance function responsibility. You're the ones trying to say to the fee earners, yes, we could do that, but should we? And if the fee earner says, well, I've already done it, well, then that's a referral to the managing partner. And if the fee earner that's already done it is the managing partner who says, well, I've done it anyway, and I know it's not part of the compliance procedures which I've signed off, well, then I'd consider my position. But that's a comfortable thing to do at 62, consider not working somewhere. If you're 32, 22, 42, that's a harder decision. And I appreciate that as well. How did I get so wise? No one's ever answered that. No one's ever said that, have they, in the AML clinic? No one you have ever had on has said,
It's
how
cert-
did I get so wise?
it's certainly the first. Are there any data sources or approaches you think are underutilized in assessing cross-border structures? So,
Oh, that's the question you didn't send me in advance.
well, are there any registries then
Yes, there are.
that
There
that
are.
firms can go to?
Um, I'll answer it in two parts.
Okay.
The client who says, well, it's an offshore structure, um, and you speak to their service provider, and the service provider says, I can't tell you who the shareholders are, is wrong because you can. If you get permission, you can tell me who the shareholders are. You can release that to me under contractual terms that I won't share it. Because if you want me to do the business, then I think you should be able to tell me that. There are registers, there are commercial registers, there are registers maintained by financial services regulators.
Mhm.
There's a debate, quite a heated debate between the UK perspective, which is driven by Baroness Margaret Hodge, Labour peer, lifelong champion of a certain view on this, which says there should be a public record of everybody who owns all wealth that's held offshore. And then in the EU, you go to the European Convention on Human Rights, and I think it's Article 7, which says everybody has the right to privacy. So in the EU, they say, well, if you can't have a public register of ownership because that breaches the human rights, it also means people who have wealthy, their children are subject to kidnap risk. And let's be honest, that's real. There's a case in America at the moment. The mother of a leading television journalist may or may not have been kidnapped. And I hope when this goes out that she's been found alive and well and safe, etc.
Mm,
Not sorry, etc. I didn't mean etc. I hope she is.
sure.
So there are registers, but there is a real issue between whether that register should be public or private. The key thing for me is that the service providers in an offshore jurisdiction must know who their clients are. They must know
Mm,
that because their jurisdiction insists they must know it. Their regulator has the right to know who their clients are. So that information is known. If a non if a foreign, as in a jurisdiction that isn't that jurisdiction, if the tax authorities or the financial investigation unit in that jurisdiction, and let's go, for example, with Norway and Jersey as an example. So Norway's taxman thinks there's a Norwegian hiding money in Jersey. The Jersey service provider knows who their client is. That information is made available to the financial services regulator in Jersey. The Norwegian taxman wants to know there is a process, there's a reciprocal process to discover that information, and it works because it's been tested and followed. So you have a situation where that information can be made available to appropriate people subject to using appropriate channels. But that doesn't help me if I'm a lawyer. What helps me if I'm a lawyer is if I go to my client and say, authorize, not ask, authorize your offshore service provider to answer every question that I put to them, because that's what I will need to decide whether to proceed. And I want to proceed. I want to take on your business. I want to support you. But by the way, I won't be doing it by 2 o'clock on Friday if you're talking to me on Thursday. There are commercial search engines, some of them increasingly sophisticated, but I won't name the ones with which I'm associated, which can help you consider the due diligence that it can obtain for you, or the enhanced due diligence it can obtain for you. But still, you need to make the decision based on that information. So there is more information available than Google. And when we come to Google, we must always remember it's a little bit like Wikipedia. And as far as I know, I don't have an entry on Wikipedia, but if I did, it would be magnificent until other people started chipping in and saying things about me which, in their opinion, should be said. If I'm an African politician or a South American politician or an East European politician or even a British politician, it could be there are people saying things about me because it suits their political agenda. That doesn't of itself mean that is true just because it's on Google. So we have to look for the bias in the source of the information that we can find on Google or other search engines are available, and knowing it's reliable. And there are commercial providers who can help you with that. How reliable is that information? You can translate things from Farsi into English with a degree of accuracy that enables you to know what the commercial transaction is in the country where they speak Farsi. And I learned that 6 years ago. So whilst I've got 46 years experience in this, I'm still learning. Learning today. Learning today that I should make sure, Michelle, if you're going to ask me questions in advance, I prepare for the answer. And I've enjoyed learning that.
That's really some really, really practical insights there, Colin. Thank you. In closing, if you had 60 seconds to convince a skeptical compliance leader that offshore involvement shouldn't automatically escalate the risk, what would you say in 60 seconds?
It shouldn't be any harder to determine whether the risk of a transaction that involves offshore is acceptable or not than if you are looking at a transaction that only involves onshore. If you don't have the systems or the skills to involve yourself with offshore clients, then don't. That's it.
Thank you.
It might not have
Short
been
but sweet.
it might not have been 60 seconds, but if it ends with do or don't, your decision, then that's the real world.
You made the point.
We live in the real world. The SRA is having its responsibility for the regulation of the legal sector passed. That will change what happens, but fundamentally, fee earners should respect their internal regulations, which should respect the jurisdiction's regulations, and the jurisdiction's regulations will be the government's interpretation of FATFA as amended from time to time. And if you're that non-cape wearing hero in compliance, then genuinely you've got to convince the fee earner to respect what the government is saying through the regulator, who has a mandate from the government, as to how you should do business. And I really think the SRA's fines of lawyers, which sometimes see people saying, oh, that's dreadful, how can that be fair? That person's reputation is ruined, their income is ruined. Well, that really just is the real world, isn't it? If I libel somebody or slander somebody, I should expect the consequences of libel or slander. And if I encourage a firm to take on more risk than they want by being less than honest, then I should have consequences for that.
Colin, I suspect we could talk about this all day, but we're not going to. So I'm
We're
going to
not
say
going to. We're not going to, no.
I'm going to say thank you so much for sharing your perspective, and I really do hope that this discussion challenges assumptions and highlights where nuance really matters, and it gives our listeners practical insights into navigating offshore risk thoughtfully. Just like to say, if you found this episode useful, consider subscribing, sharing it with your colleagues who live in the world of nuance, risk, and razor sharp judgment calls. And if you've got a topic you would like me to cover, I would love to hear from you. Thank you for listening to the AML Clinic. Until next time, stay informed and stay compliant. And thank you, Colin.
My pleasure, Michelle.